I'm Ben Meiselas from Legal AF, joined by Karen Friedman, Agnifilo. Karen, let's talk about what actually went down at this blockbuster hearing in the Northern District of Georgia, where Donald Trump's co-defendant, Mark Meadows, in the sprawling RICO criminal case being prosecuted by Fulton County District Attorney Fani Willis, made the shocking decision, shocking all legal analysts, including myself, to waive his Fifth Amendment rights against self-incrimination and to testify at this evidentiary hearing that was held on Monday. This evidentiary hearing related to Mark Meadows' efforts to try to remove the case from state court, Fulton County Superior Court, to federal court. Judge Steve Jones is the federal judge in the Northern District who presided over, who is presiding over this matter, presided over the evidentiary hearing. Mark Meadows would have to show three things to get the case removed from state court to federal court in a criminal case like this: that he's a federal officer acting under the color of authority of federal law, and that he has credible federal defenses. He has to show all three. And one of the issues was Mark Meadows needed to, in a court of law, put forward admissible evidence to try to make that showing. The burden is on him. He can't just make arguments in a legal brief. And so apparently couldn't really get any other witnesses to testify. And so he testified on his own behalf. Waived his Fifth Amendment. His testimony was for several hours. And what he and his lawyer, he's got a good lawyer. I'm not sure I think this was the smartest decision to make, because I think, as we'll talk about in this video, Meadows appears to have kind of further incriminated himself in trying to get this case to federal court, and this kind of Hail Mary move that he and his lawyers are making. But what his lawyer kind of wanted to stress over and over again is that the removal statute in criminal cases, they repeated this over and over again: low threshold, low standard, even a scintilla of evidence, even if there is the slightest degree of nexus between what Meadows did with a federal official duties, then, judge, you have to remove this case to federal court. The other issues about whether Meadows was acting as a criminal, whether Meadows should be entitled to immunity, let's litigate that at the motion to dismiss stage, or summary judgment stage, or a trial. But for now, Your Honor, the question is there even the slightest nexus to a federal duty? And if so, this has to be removed to federal court, is what Meadows argued. Fulton County District Attorney Fani Willis's team said, what are you talking about? It's a criminal enterprise is what's going on here. That's not constitutional duties trying to overthrow our Constitution. And in any event, just look at what Meadows is saying that he did. He's admitting it's political activity. As the former chief of staff, chiefs of staff aren't political people. They're supposed to be executive branch people. If he's political, that's a violation of federal law. That's a Hatch Act violation. So you can't remove the case to federal court citing a federal violation of federal law. So that kind of is the framework that I wanted to set the stage of what took place in this hearing. But let's talk, Karen, about Mark Meadows, what he actually talked about. Did he further incriminate himself? Brad Raffensperger testified as well. What did you make of this hearing, the actual substance of what took place?
Yeah, this was a Hail Mary move on the part of Mark Meadows that, frankly, most people did not anticipate, because it is so unusual for a defendant, a criminal defendant, to take the stand at this stage and make the statements that he did make that can incriminate him. I mean, look, for him, he's like, look, the facts are what they are. Everything's either recorded or a text message or an email, or witnesses who testified spoke to January 6th. And so there's many facts he can't deny. There were a few times when he says, I don't recall, because of course, that's cue for, that's a bad fact I can't admit. So I'll not recall that. And he just basically is like, look, my defense is not going to change. So I'm going to put it out there now, prior to seeing what Fani Willis's evidence is and was. And he put it all out there to be cross-examined by Fani Willis. We haven't released and seen the transcripts yet. I'd love to see them. But one question that was not asked that I was hoping would be asked was, are you cooperating with Jack Smith, right? Everyone wants to know that. Or what exactly is your arrangement with Jack Smith? Because he's not indicted in that case. He's also not mentioned as an unindicted co-conspirator. So it would be great to know what exactly his relationship is with Jack Smith and what deal they might have. And if I'm the federal judge, I'd want to know, because it is sort of weird that he's not charged or mentioned in Jack Smith's case. So I thought that was a strange omission if it indeed was not asked. And I think it wasn't asked because otherwise I think we would have heard about that, since that's the big question everyone wants to know. And he did incriminate himself in the sense that, Fani Willis has to prove her case beyond a reasonable doubt. He has no burden to prove anything or show anything or do anything at a criminal trial. His lawyer could sit there and not open, not close, not cross-examine a single witness, not put on any evidence. And if Fani Willis doesn't meet her burden, she will not get a conviction. She still has to prove the case beyond a reasonable doubt. Well, he helped her, right? He corroborated a lot of the things that she was saying, that phone calls were made and arranged and he was present, etc. So there's going to be a lot of facts that he admitted right there that I think will hurt him ultimately. I think he also set himself up for a potential Hatch Act prosecution if the Department of Justice wanted to go after him for that. He admitted to engaging in all sorts of campaign-related crimes, frankly, and so that's something I think he's going to have to engage in. And the reason I say he committed those crimes under the Hatch Act is because he admitted to working on a federal campaign while he was chief of staff. And that's a no-no. There's a clear, bright line between politics, campaigns on the one hand, and working for the executive branch on taxpayer dollars and using taxpayer resources, the phones, the emails, your time, your salary, everything. I mean, it's really important to keep that line a bright line. And he admitted that he crossed that line every day. In fact, he viewed that to be part of his job, was everything Trump, including candidate Trump. So I think in some ways if this case does proceed against him in state court, I think he did help Fani Willis by admitting certain things. But if it gets removed to federal court, first of all, the whole case could get removed. It might, even though he's the only one making the argument thus far, all the other defendants are closely watching. And so it's possible that they could also make a removal motion. It's also possible that the judge could say the whole case is coming up. He has the discretion to say one defendant or all defendants if he thinks it belongs in federal court. And although I think from what we've heard, I don't think Mark Meadows met the threshold, even though it's a very low threshold. I don't think he met it by his testimony. But I do think this judge is going to be thinking about potentially being reversed by the DC Circuit, as well as ultimately the Supreme Court. By the 11th Circuit. As well as by the Supreme Court. The 11th Circuit is quite conservative. And so he's going to be thinking about that, because by being reversed and getting it to the Supreme Court, that could cause delays. Again, the thing that nobody wants. So this judge might say, look, it's a very low threshold. I'm going to let it come to federal court just to keep the trains moving on time. If that does happen, and like say Ken Cheeseborough and Sidney Powell and John Eastman also go up with Mark Meadows, then there would no longer be a speedy trial. There'd be a slightly different jury pool. It wouldn't be televised. So it would be a very different ball game. But that's a possibility of what might happen there. And I think we all have to watch this very closely, and I suspect he's going to want to rule before September 6th, which is when everyone's going to be arraigned in this case. So I think stay tuned, and we'll know a lot more very quickly here.
And so no ruling's been made yet. What Judge Jones did tell the parties is that if I do not make a ruling by September 6th, you'll have to show up at your arraignment. We've talked about that issue before, right? Because Mark Meadows filed an emergency motion to get Judge Jones to try to block the Fulton County Sheriff's Department and the Fulton County District Attorney's Office from pursuing his arrest and his surrender, and basic laws, basic federalism principles in our Constitution say until the federal judge makes a determination about whether there is federal jurisdiction, the federal judge has to be hands off on the state proceeding. So Judge Jones is recognizing that principle of federalism. It's always an irony to me. The irony is not lost that you have states' rights people like Mark Meadows asking for federal jurisdiction over matters and asking to block state prosecutors from engaging in their sovereign prosecutorial powers. But look, Judge Jones says, I'm not ruling yet. If I don't rule before September 6th, show up to your arraignment. I'll try to rule before September 6th. But one of the things that I noted, Karen, as well, is that Judge Jones was asking a lot of questions himself. You learn a lot about the different judges, their temperaments. You see how Judge Eileen Cannon acts and the disorganization there. You see how Judge Chutkan acts in Washington, D.C. case. Judge Jones wanted to ask a lot of very kind of probing questions here, also to Mark Meadows' lawyer. So is there any limit? And I know you keep saying low threshold, Mark Meadows' lawyer, but does that mean you basically think that anything, and Mark Meadows' lawyer kind of dismissively said, well, we can't go to Lafayette Square and then start shooting people, and kind of the ultimate irony of that is that's something that Meadows did. With I mean, it's not related to this case. Meadows did do that, with Donald Trump, and they used the military. We saw that happen during the Trump administration. So, perhaps a Freudian example given by Meadows' lawyer, but Meadows' lawyer did mention that, and I think that's where Judge Jones wasn't buying that. And Judge Jones also was asking questions of Brad Raffensperger, the Republican Secretary of State of Georgia, his impressions about the phone call and whether he thought that was a normal phone call that he would have with the chief of staff. And one of the arguments that Meadows' lawyers tried to make was that this was a settlement negotiation. That's why this call took place. It's an absurd argument. What they were really doing on the phone call that we've all heard, this was a settlement negotiation because Trump had filed these lawsuits. Well, what settlement negotiation are you talking about? As we as lawyers know, if there is settlement discussions, you say this is a settlement discussion pursuant to Federal Rule of Procedure, 408 or the applicable state rules. So it wasn't a settlement discussion. And Raffensperger just said, no, that was absolutely not a settlement discussion. That was bizarre. I've never seen that before. And Brad Raffensperger shared his impressions as well. So interesting that Judge Jones getting involved like that. Karen, to your point, it is a low threshold, but I don't think that Meadows made the low threshold. Agree wholeheartedly with your point as well. Judge Jones is probably thinking, though, depending on who this 3-judge panel is in the 11th Circuit, he can get reversed very quickly, and you can see in 11th Circuit 2 Trump judges, 2 George W. Bush judges, a George H.W. Bush judge, whoever, basically saying the exact argument that Meadows' lawyer said. Low threshold, there has some nexus to it, even if it's criminal, there's some nexus that makes it go to federal court. Any final thoughts, Karen?
Just that if he does get removed, that's step one into his ultimate goal, Mark Meadows, which is to say, I'm a federal officer, I was doing my job, and therefore, state, you can't prosecute me. The Supremacy Clause controls, and I'm immune. So that's why this is such a Hail Mary, is because he's going to argue that he can't be prosecuted at all. So stay tuned. A lot's going to happen in the next couple of days. People should pay very close attention.
Well said. Everybody check out MeidasTouch.com for all the breaking news, all things MeidasTouch. Go to MeidasTouch.com and wherever you get audio podcasts, make sure you subscribe to the Legal AF podcast and have a great day.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.